What up, what up, what up, you guys? It's your girl T.U.O coming back with another clap back. Well. I'm feeling a little better today, just to let y'all know. So, I was sitting up here minding my business, enjoying the little vacation we get, right? And y'all holiday. And, cooking my greens and oxtails and cornbread. I think I uploaded a picture. Go check it out. But if I didn't, I'll upload it. But anyways, and I'm over here, scrolling through Instagram like I do, and sending over some of the videos that I clock to Mr. Porter. Just to have discussion, just open discussion. And I guess especially because he was posting videos and stuff on his page and everything, trying to promote the BS that we know is BS because we going through the docket, right? Um, he decided he wanted to block me because I was telling the truth. I would He would post a new video. I would go under his video and I'd be like, "Hey, check out my video on the status of his case." And he was mad, so he decided to block me. He decided to block me. He was mad. And I said, "Okay, that's cool. That's cool. That's cool. That's cool. That's cool. That's cool. That's cool." But I'm still going to clock it. I'm still going to clock it. And so I decided to check the docket today. You feel me? I decided to check the docket today. And I came across a newly submitted document by the defendants. Now, before I get into it, I do want to have a discussion about a few things. Okay, I do want to have a few discussions about a few things. First of all, one thing for sure. These dudes online be sitting up here, how you say, like they be sitting up here attacking women online because that's the only way they can engage with a woman. You feel me? They don't know how to have an open discussion without attacking her, especially when they're wrong. I've been wrong a few times online. And you know what I say? Never mind. You were right. My bad. You got it. I apologize. Sorry. There was one time and it's just like little frivolous BS, right? It was miscellaneous stuff. And we were having a discussion. It was about Rev Run talking about he's the greatest rapper alive or something. And I said, wow, to say you're the greatest rapper is kind of a stretch. Or I said, that's crazy. And the male, the males start jumping in my comments. And one guy particular, he was like, "You must not know about Run DMC. You don't know nothing about them. The audacity of you to be talking or whatever." And I was like, "Actually, I do. I'm aware. I know it's Rev Run. I know it's DMC." And I was like, "What's the DJ's name?" And he comes back with some insult or something to me, like, "See that? You don't know shit. You don't know nothing," or whatever. And I'm like, and he was like, "Run and DMC." And I said, "Wow, you're insulting me, but I asked a question. I just was asking a question. You didn't have to insult me. I'm just trying to have a constructive conversation with you, or friendly debate. It don't even have to be that serious. The way you act like you put money in these dudes' pocket, or they put money in your pocket." And he just went in on me, and then he was like, "You didn't ask me no question." And so I had to literally DM him a screenshot of me asking him, "What is the DJ's name?" And then he gonna say, "Oh, my bad, my bad. My fault, my fault." That's what he said. And I said, "No. I need you to apologize because you just cussed me out, talked about me, dragged me through the mud like a dog. You so quick to drag me through the mud, but you're not so quick to apologize. And I said something like, quick to respond, slow to apologize. And I basically was quoting the scripture where it says, quick to listen, slow to respond, I believe, or slow to anger. One of those, right? And he was like, "Oh, I already said I was sorry. I said I was sorry. I said my fault." I was like, "If that's what you consider an apology, you need to work on that. That's not really mature of you on your end because that's not a real apology." And I was like, "Since you don't want to apologize to me, you can't acknowledge your wrongdoing. I'm going to do you a favor and I'm going to stop talking to you." And that's what I did. I just ignored him moving forward. Um, he did acknowledge it publicly that he was wrong, but still, I'm the type of person you gonna drag me through the mud. You also gonna kiss my goddamn big toe in front of everybody. Yes, you gonna kiss my ass because I didn't deserve that. Another one is this slumlord. Oh my goodness. There's something wrong with these dudes. So there was this lady who basically got evicted or she left, whichever one it was. There was no real context, right? I came across the video and the dude was like, "Man, look how she left my house. Look how she left look at this." And he going through all the rooms or whatever. It's a mess. It's toys, clothes, doo-doo everywhere. Well, excuse me, feces everywhere, and it just looks disgusting. I don't see particularly any holes in the wall. I don't see any true damage besides that, right? Besides things left. I don't even see anything like a heavy load. There was a mattress, I think. Well, I don't think. There wasn't a mattress in the basement. Um, that was the only thing that would be of heavy load to carry out, and it had feces and whatever else on it. And I was like, after looking at that, he was like, "Oh, what pissed me off about the video was he put her number out there. He was like, yeah, here go her number. Call that B, cuss her out. Check, cause this B is out of control. She trifling as wooty wooty woo." And I said, anybody that called that lady is as a block. Okay? Because first of all, it's not you guys' responsibility to be checking anybody on his behalf. Who is he? He don't put no money in your pocket. You will have to call this lady. You're gonna take time out of your day to call this lady and you ain't even get paid. And then considering that will be considered harassment. Across the lines, it may be federal. I don't know. I can look into it if you like. But why go through all that? And then he gonna hit me back. I said, it's his responsibility. It seems to me that he's a slumlord, basically. Cause how long she been there and you ain't been to the property not one time to check on it? This is not overnight. This is it takes time to build up like this, right? So he hit me back in the comments. Oh, first of all, B, uh, something should. I don't even feel like going through it. Okay, I don't even feel like going through the comments. He was like, basically the highlights that I remember is he basically said that she left the door open, which caused animals to come in and cause all that feces to be everywhere. So it wasn't even her kids or anything like that. And I said, "Oh, okay. So it's a possibility that one of the kids accidentally left the door open." It's not, I don't know if it was all the doors open, but he just said left the door open. So I'm assuming it was one. And so I'm like, okay, it's a possibility that the kid a kid left the door open, because I can't see a responsible adult leaving the door open unless it was how you say intentional, vindictive, right? And so then he's like, I said, but it still doesn't address. And I think he said, "Oh, I've been to the property every week. I go to the property every week." And she would, I think he said she would ignore my notices, and she wouldn't answer the door. And I said, even if she didn't answer the door, you have the right to go into your property and check on the conditions of your property. If you give them proper notice and you say, "Hey, there will be an inspection on such and such date. Please be there," or whatever, and they still not there, you have every right to still enter the property, um, even if they're there or not, by your right, as long as you give them notice. And it just tells me, out of all the time that she was there, you didn't go look. And so that's just what I'm telling him. And he just coming back, "B, shut the F up. B, you stupid. B, you dumb. B." I said, but you still not addressing the fact that you ain't go look at that property though. You talking about everything, you calling me everything else, but you're not addressing. And I tried to make a point, especially this year, of not getting into the mud with people. I can and I may, but I'm working on not getting into the mud with people, because I can slice and dice. Whew. And I think New Year's is going to be my release, but I'm just trying to hold it. Hold on one second. My bad, my bad. Um, so Um, I, I just addressed him cordially and addressed the argument. I was like, "You still ain't talked about how you ain't go check on that property." And I said, "Well, then it's not her fault that there was feces everywhere. That it was the animals. So it's really not her being trifling. It's the fact that," and I'm just like, "But you," and then this other lady, she got on, she was like, "Girl, please. If he want to go ahead and go that way, that is considered harassment. He can have a lawsuit against him real quick." And I'm thinking about doxing people. Like, you over here doxing her and her information. That's crazy. That is crazy. I hope she come across this video and sue his behind. Okay. And I think my algorithm is on some, like, a lot of BS. It's a lot of men that don't like women out here. It's starting to become, and I don't want to hear, "It's not all men." It's a big ass majority. The scale is leaning heavily on the dislike side. I put on the post, I put a comment on the post. I was like, "Ladies," because the dude was like, "How about you go ahead and shoot her a couple of dollars, send her some flowers or something?" And then the other guy, the Stitch, was like, "How about you do it, nigga? Because I ain't got to do all that. I could give a girl a bare minimum." He didn't say it in these words. He used deplorable language, but he said, "I can give a woman the bare minimum and she's still gonna give it up." And all I put under under the post was, "Ladies, keep your legs closed." I said, "Hold the line, ladies, hold the line. Keep your legs closed, cause these batch of men, they gonna get it. They gonna get it together. We gonna whip them in line, okay? Ain't no way. Just as easy as it was for ladies to accept bare minimum because you broke Negroes didn't have $1 to your name and they decided to work with you and give you some and try to um, invest in you, and you decided to misuse that. We're not doing that. As easy as that was, we can flip it on you and be like, oh, we're policing this coochie now. No more. Legs closed tight. Niggas talk about some, don't nobody want that. I'm sure you believe that. But if I put my thumb out there and be like, come get this cat, somebody gonna sniff it. I guarantee you that. I guarantee you that. You can sit up there and believe what you want to believe. You can put out fake news. Shoot. Just as easy it was for Bill Clinton to get his okay? It's just more easier for me. Okay. It's more easier for me. Oh, that's why you single. No, beast. I choose because y'all be carrying diseases. Y'all be giving it up like it's tic tac. Knick knack, paddywhack, give a dog a bone. Okay? That's what y'all be doing. And don't nobody want that dirty thing. We are starting to find out science is starting to provide information because I believe at a point in time it was male dominated. And I strongly believe that other groups of individuals got into these fields, these job fields, and start telling the damn truth. Because now we finding out that Down syndrome don't come from women. Sickness don't come from the women. Diseases is not passed on by the women. It's all from men. You dirty carrying, disease, disabled bad genetics, old sperm carrying. Ugh. It's creeping out. You feel it? It's creeping out. I'm trying to hold it. Let me get it together. Okay, like the audacity of y'all be trying to drag women through the dirt with y'all. Like, no, we are not like you. They're not like us. Ladies, they're not like us. And I'm not saying that all women are perfect or they keep even the horse, right? Even the hus, okay? Haux, even those, they put a price on it though. Okay, and they pick and choose who they gonna do. These dudes don't pick and choose. They go for whatever is willing to. And not everybody, but the majority ain't got no standards. Okay, so please knock it off. Knock it off. Just knock it off with the woman hating. I feel like work on yourself. I think definitely, ladies, we definitely need to keep our legs closed until these dudes, until like our vetting process definitely needs to include, have you been in therapy? And we need to see it just like a STD check. We need to see documents to say I was enrolled in therapy from this time to this time, or I am currently enrolled in therapy. And how long you been in therapy? I don't need to know what y'all talking about. I would hope that you processing some of your trauma, but and people that be talking about something, I don't need it. Even if you think you don't need it, how about you just do it for a couple of months to see if it's something that you didn't know? Like, that's the whole point of therapy, is to, what Charlemagne says, unpack some things you may not have thought was trauma or an issue in your life. That's the whole point of therapy. So, ladies, if a man has not been in therapy, does not intend on going on therapy, just know you're going to have a headache. Okay? Especially if he's not, and you have to be careful with that, but having a close relationship with God, look, I'm a person that teeters as well. I'm on a vacation on this sailboat far out in shore, but I'm trying to draw back in. It's there. I got that mustard seed. But if a man doesn't have morals, and I think I saw what's his name, the public offender. I saw a couple of his videos today, and no, was it him? No, it was something on Instagram, but they were talking about Russell Wilson as well. I think Russell Wilson is the topic of discussion because that guy is dragging his name to the mud. But the guy was like, a lady friend of his asked, uh, how do you point out or are able to uh, how you say it? How are you able to I forgot how you put it, but how are you able to see a a red flag? How can a man I don't forgot the wording, but what is a red flag that a woman should look out for? I'll say it like that. And he gave an example of um talking to a man and asking him, you having a conversation, and he says, asking him, what is your thought process of Russell Williams? And if the man says, oh, he a simp, and then you go through the things that Russell Wilson is about in his life, legitimate job, successful, was willing to take quote unquote a baby mama in his life and build her up, have more kids with her, raise her child to be his own child, um, is not slandering anyone in the streets, um, has a good head on his shoulder, Christian, so forth and so forth. And that man that you're talking to is saying that he's a simp. That means he goes against everything that Russell Wilson is, and that's the man you're gonna choose to be with. That's how you can catch a red flag. And I was like, that is pretty good. And I think that is something I would do. Like several things that I would do during the vetting process. And I think that's what we need to start doing. We need to start listening. Um, I felt, I don't know if the word is vindicated, but I felt accomplished when someone I used to know, I allowed them to sleep over my house and they tried to low key have sex with me. And I was like, no, it ain't that type of party. I'm just a friend looking out for you at this point. You haven't shown me anything that we're going to move forward together. You've shown me everything but that. So I'm keeping this kitty cat to myself. You go hump on somebody else. And ever since then, I've been feeling like, oh, I could do this. Hell, I could tweedledum my own self. I got a shower head. I am so for a detachable shower head. Ladies, get you one, and I bet you won't look at another nigga. You like, please, nigga. I got a nigga at home. His name is Tom Shower. Okay? Get out of here. So not only do I keep my twat clean, it's also wet. Excuse me, I'm being vulgar. Let me stop. But I really hope that men can get it together. I know a small group of men are trying to straighten these men out, especially the up and coming men. It's just sad. And I do want to address one more thing. Speaking of the up and coming uh men, I keep hearing this thing about, oh, that's why a father needs to be in the home. If a father was in the home, this wouldn't be happening. Let me tell you something. I don't agree with that statement. A man needs to be in the home. That statement, that need, I'm like, no, nobody needs nobody. It is wanted. You definitely want two parents, and there's so many pros to having a two-parent household. It's just not about, oh, the structure of the child and their upbringing. It's definitely not that. It's definitely working together, carrying the loads is the majority, because we've seen multiple men be raised by single parents, um, single parents, and thrive. Upstanding gentlemen, upstanding women, right? I believe it's about your environment, your structure, your decisions at the end of the day, right? I can do a anecdotal and say for myself that I began off the wrong road. It was a yellow brick road, and then I went on into the woods, okay, in the gutter for a moment. And I began to, get closer to the track until I got back on track. Thank God I didn't end up in jail or in the ground, but people live their lives. You can only do so much as parents, as supportive friends, as a family friend, as relatives. It's only so much you can do, but you're not I me personally, I'm not going to beat myself up to make another person do anything. There is a certain amount of time that you do implement structure onto a child, but at a certain age, what can you do? And when I think about is for girls from 15 up, it's really only so much, because all they want to do is be some hotheads. And y'all seen what them kids was doing, and it seemed like it's getting younger though. 12. So y'all seen what them kids was doing. And I do want to point out the fact those kids in Chicago, it wasn't just single mothers. It was definitely a single father in that situation. So it doesn't matter if there is a father in the home that wouldn't have happened. Yes, it does happen, because these children, and when I say these children, I also mean these individuals, because it could be boy or girl, different age range, make their own decisions. You can't stop anyone from doing what they're going to do. No matter how much Bible thumping, no matter how much preaching you do, there, because I'm like, it's some preacher kids out here that be sitting up there having babies out of wedlock, having babies be at teenage years. Like, come on, stop. Y'all need to really start with that remark, that talking point, that comeback. I just get tired of that. And it's just like, well, if the father is so important in the home, why does he choose to not be present? I don't even care in the home, just active in the child's life. I don't want to deal with she making it. It's just a lot of excuses. Where is the third party at? Who is a neutral person between y'all? Who is the neutral person? Because I know as a boy mom, my number one thing is that ain't got nothing to do with me. Leave me out that mess. I will I will listen and try not to judge, but at the end of the day, when it comes to the child, I would definitely be willing to be the third party in making sure that, hey, to make sure it's a smooth transition. I think that transparency is important. Some adults are just not capable of that. Um, to say, hey, this is where we're at in our relationship. We're not getting back together, but I definitely want to be a present, active parent figure in our child's life. And, let this person be the middle person. We don't have to really engage like that. I'm willing to do that. I'm not going to be arguing with nobody. And I ain't about to be sitting up there having no discussion. Be adults and work it out, But most people don't know how to do that. But I think that's the last thing that I wanted to address. Fathers are not the only ones that's important in raising a child. And the only reason why mothers are the uh, primary custodial parent is because fathers forced them to be. I didn't heard a few people talking about some uh my husband decided to walk away from his family. I was like, it's a choice. I didn't know it was a choice. I didn't know that. I thought like when you have a child, you have to. But it just seems like no, I don't even care how trashy a parent is. I don't care how trashy a parent is. Is that parent putting a roof over that child's head? And I don't mean no SA. I don't mean no PED. I don't mean any of that. Of course not. I don't mean a substance abusing household, but I'm just saying it may be some emotional abuse because being a single parent is difficult, right? But besides those things that I named, if that parent is putting a roof over that child's head, why are you complaining? Why are you complaining so much? They're doing the best they can. I encourage men. I encourage men to please seek therapy, seek substance counsel. Um, please get some type of finances, some stability, become emotionally aware, and get custody of your kids. Ladies, please give these men their babies. I really encourage you ladies to give these men their babies. I saw a video. I don't even know if I have it saved anymore. But I saw a video where a man had custody of their kids. I think there was more than one. I may be wrong. But and the lady lived either an hour or something away. She lived some time away. And she was basically the baby daddy. She was paying her child support and she had visitation. But I think she was like, oh, she was doing the whole baby daddy thing. I can't get him this week. And he was calling her. I don't even know if it was that, but he was calling her saying, can you send me some more money? Because these babies be. And it was not a skit, it was for real. He was like, you don't even help me. I ain't got no money. Ah. Ladies, if you give these men custody the way they sit up here hollering, I guarantee you their tone will change. Give them babies. Give them the babies. Give them the government assistance. Cause guess what? You ain't gotta worry about no child care. You ain't gotta worry about no babysit. I keep calling it babysitting, but you ain't gotta worry about watching over no babies or nothing. You gonna be free of children. And in that time, I give it 6 months. I give it 3 because that's how long mine's lasted. 3. I gave him to him. I did. I said, your turn. Tag, you're it. He only lasted 3 months. He said, I can do it. I never did this before. Mind you, he wasn't even a baby. He wasn't in diapers. He was 8 years old. Like, come on. 8. Talked and everything. Goes to school around the area. Stay 5 minutes away. Okay. So give them babies. Give them the government assistance. And you go back to work. You get your career together. Go back to school. Invest in yourself. Go to the gym. Go out on, don't do too much now. Don't get another baby while the baby's gone. That's not the goal here. We want to pour into ourselves. That's what we want to do while we have that vacation, is what I call it, because it ain't gonna last that long. While we have that vacation, invest in yourself. Take that time to get yourself back into your sexy mode, back into your old self, but not your trifling self. Let's not do that. Let's be a better person. Let's build our relationship with God. Let's work on that. Um, what was I gonna say? Um, I forgot what I was gonna say. But yeah, it wouldn't be smart to have another baby while your baby is gone. That you starting over. Like, and I want to see how many men gonna be like, okay, I got the baby, and guarantee you too, ladies, they gonna have somebody there. They gonna have a girlfriend or two there. But ladies, get your protection and talk to her. Talk to the girlfriend, the wife, whoever this person is, right? But like, oh my God, I'm so glad you're here to help, right? And just get around to the conversation of saying, I got a closet full of guns. I go hunting. Have you ever hunted before? I go hunting every week. I got this AR. I got this 37. I got this deuce. I got a silencer. Because I can silence it. Okay. You got to insinuate some things. So when things come to fruition, they know, they take a double take. They think about it like, I ain't even trying to mess with you like that, because my life ain't worth you. So, but guarantee you these men are going to have partners. They're not going to be doing it alone, and guarantee you it's going to be okay. And don't argue. Please do not be mad that he going to have somebody else. You really need to work on leaving that relationship alone. Even if the person come back talking about some, hey, oh, that's what I was going to say. Hey, can we get back to, no. Especially you got to put that time in. You're going to be putting this time in, this prison time by yourself, and he got the audacity after a couple of months to be like, can we get back to, no. I did it for 5 years, 2 years, even a year is too much. But I was going to say, even if that man decides to keep your baby until they 18, so what? You get visitation, show up to your visits. If you can't make it, communicate, hey, I can't make it this week, ahead of time, you know. And you ain't got to tell them what you're doing. Just like, I can't make it. My schedule does not align with my visitations. But if you need, I can get her the following week and get back on schedule. The following week is after that. You know, it's just all about communications. But okay, I've lingered so long onto that discussion of men hate women, and hopefully women whip them in line. Please, I beg of you, please whip them in line. Keep your legs closed. Give them babies. If it's DV, no. If a man is sitting up there weaponizing all that stuff, no. Okay, I still support that. Abuser, no, we ain't doing that. And we're gonna start seeing how many of these dudes gonna be like, me, I want my baby. I want my baby, please. All right, let's get into Mr. Porter. So last week or so, we read through Mr. Porter's complaint. We skimmed through it, and his amended, the motion to dismiss by his child's mother. I won't call her baby mama, but by his child's mother, which was flawless. It was beautiful. He removed her off that case. And then he refiled a proposed amended complaint, which was accepted. And we read, well, actually, we didn't read through it, which is what the defendants is going to address. I want to, but then I don't want to. I'm going to be real with you. I don't. He filed an amended complaint and it was accepted, and the judge accepted it and said that he needed to file it. But then, okay, then the defendants requested for a motion to dismiss, saying that he hasn't asserted his he hasn't asserted any relief, any damages to him, and it wasn't the correct venue or jurisdiction for him to bring a lawsuit. Go look at my other video to get more. I read through it. Now, Mr. Porter filed a response to the motion, or an opposition to the motion, and defendants have replied, right? And so I'm gonna go through Mr. Porter's opposition to the motion real quick, but the reply to the opposition is sweet. Okay, I just want to go through this real quick. Seven. Give me a second. Seven. Open it in another one. And then give me a second. I'm trying to see what's different, because that's what the defendants are asserting, that the complaints are they're different. Just like that, I got it. So it looked like he removed, oh no, he added some things to the amended complaint that was accepted on page 5. And I just guessed. To, let's see, what is this? 6. Yeah. Yeah. What is that? I'm sorry. Yeah, he did. He added that $1 million in the relief. He didn't assert it. He didn't assert it in the proposed amended complaint. And so let's go back, okay? It's just a lot of stuff. It's a lot, but I love it. It's humorous to me, because I don't want y'all to be scammed. That's the number one thing. And for him to have so much vitriol in his position that basically women are alienating the children from the father. I'm like, what evidence do you have? And I'm just tired of these men. I feel sorry for you guys because you guys are being misled by your emotions, for one. And two, he's using that stuff. He's yelling from the rooftop about black women because you guys are going through your own stuff. Let me see, how am I trying to say it? Like, first of all, every situation is different. Okay? In his case, in Mr. Porter's case, right? He had to go through therapy, parenting classes, and anger management, which tells me he has an issue with his anger. Even the way he was speaking to me, I was like, I just was trying to have once again an engaging conversation about his belief. But since he wanted to verbally attack me, I was like, oh well, then I can dig a little further. You know, for him to, he's misleading you guys with his emotion, and he's getting $1 out of it. And it's sad that you guys don't see that because you're being misled by your emotions. I want you guys to do better for yourself. Like, I want you guys to see better, do better, because it's not healthy. It's not healthy to allow someone to manipulate you into wasting your dollars on them, on the court system. That stuff is not cheap. It is very taxing. It's emotionally draining. You think you're going through some emotions right now? I'd rather go through some emotional whatever issues that I have with my spouse, my partner, than the court system. It's draining. Most of you guys know that. But he's playing on your emotions so you can, he not about to win this case. Let's get into it. Let's get into it. No, I don't want the reply. Did I get the reply? So I want to go to his memorandum. He filed the same day. I don't know why, but he did. So oh, I didn't know you had to do it like that. That's pretty good. I think he be sitting up there. I think he how you say, he got this. I feel like he copied and pasted this information from Chat GPT. That's what I feel like he did, low key, because I'm like, this is too professional. You ain't had a lick of lawsuit or anything. And he used AI a lot, so that's the reason why I believe. I really don't care about the introduction. You guys know how he got here. We went through that already. Go watch my other video. It's just gonna be repetitive of what happened. Um, I'm sorry. This is the defendants. They have their dismissal request. This court has already determined that plaintiffs' First Amendment access to court claims against defendants Primo, O'Connor, Dixon, Esteen are not frivolous and may proceed in normal course of litigation. Defendants now seek to relitigate the determination thorough a procedure defective motion that attacks the wrong pleading, ignoring the court screening order, relying on improper evidentiary submission, and advanced immunity defense that cannot be resolved without a factual record. Defendant's motion fails for 5 independent reasons. I want to see. I think I already read this in my last one. But just to go through it real quick. The motion is procedurally defective. Second, defendants ask the court to disregard its own screening decision. Third, plaintiff has adequately alleged a forward-looking access to court claims. Fourth, judicial immunity does not apply. Fifth, quality immunity is premature. Title 4D contents. A county participated in federal Title 4D support program and received $594,791 in federal performance incentives payments in 2022. Sure, okay. Defendants Primo refused to accept filings, dismissed paper, refused assistance. Dixon and Primo. Dixon initially accepted filings after consulting Primo, reversed and refused, forced plaintiff to mail. Dixon denied receiving mails, filing despite plaintiff proof of mailing. O'Connor and Eckstein. O'Connor timestamp filing at 3:53. Provided receipt filing later. Disappeared from the records when confronted. O'Connor summoned Esteem. Esteem cleared clerk area. Summons bailiff. Had plaintiff thrown out basically. Um, procedural entrapment, excuse me. On June 4, 2025, the family court directed plaintiff to serve papers on or before June 16 for a June 18th hearing. Plaintiff complied, serving on June 11th. Exactly 7 days before the hearing on June 18th, the same court dismissed the motion untimely under CPLR 2214B, which requires service at least 8 days before the hearing. Requesting harm. As a result of defendant's obstruction, plaintiff's driver license was suspended on June 6th. Wage garnished. Plaintiff was denied hearing on his judicial challenge. Plaintiff was forced to incur $29 in express mail cost after in-person filing was refused. Defendant's motion improperly targets a supersede pleading. Defendant's motion is procedurally defective and must be denied because it seeks dismissal of the wrong complaint. In their attorney declaration, defendant states, I make this declaration in support of defendant's motion to dismiss pursuant to Federal Rule Civil Procedure 12B6, seeking dismissal of the proposed First Amendment, amended, verified complaint against all defendants with procedures. But the proposed First Amendment complaint, the verified complaint, is not the operative pleading. On October 16th, the court issued a memorandum decision in order holding plaintiff amended complaint is accepted for filing as the operative pleading. Plaintiff is directed to file a copy of his proposed pleading as the amended complaint within 10 days of the date of this memorandum decision in order. Plaintiff complied the same day, filing the First Amendment verified complaint. I wonder what's ECF. I know it's basically docket number, but I don't know what ECFS stands for. What the acronym is. That is the operative pleading, not the proposed version lodged with objection at 42-1. Well, the issue with that, Mr. Porter, is that you changed your First Amendment verified complaint. That's the issue, sir. So that's why they're addressing it. And they're dismissing your Second Amendment amended complaint. Okay, the court already held the claim plausible at screening. While defendants are, of course, entitled to file a Rule 12b6 motion, that motion must be elevated in light of the court's prior conclusion that the claim is at least facially plausible and not judicially barred. Defendant identified no new facts and no intervening law that would justify a different result as this early stage. First, the court has already determined plaintiff's allegations are sufficient to survive screening under the heightened T.U.O standard, which permits dismissal only when it is unmistakably clear that the case is frivolous. Second, defendant admit this finding exists. Their attorney declaration acknowledged on October 16th. This court issued a screening order regarding the proposed First Amendment verified complaint and found only the First Amended access, excuse me, that only the First Amendment access to court claims pursuant to 42 U.S.C. Section 1983 against defendant survived review. Third, defendant present no new facts that would change the court analysis. They rely on the same factual record this court already reviewed. Fourth, defendant presented no new law and would change the court's analysis. Rebuttal paragraph. Defendant's motion effectively asked the court to revisit its October 16, 2025 screening order in which the court already concluded that plaintiff's First Amendment access to court claims do not on their face establish a lack of subject matter jurisdiction, nor are they frivolous as a matter of law, and that these claims may proceed in the normal course of litigation. Defendant presented no new facts or law that would warrant disturbing that prior determination in light of the screening order and applying the Rule 12B6 standard. The motion should be denied. Plaintiff plausibly pleads a forward-looking access to court claims. Defendants assert that plaintiff failed to state a claim is contrary to both the factual allegation and the court screening order. The First Amendment verified complaint plead in detail chronological form a substance pattern of clerical obstruction that prevented plaintiff from obtaining timely judicial review of jurisdictional challenge. Contrary to defendant's characterization, plaintiff does not allege mere inconvenience, but instead a continuous sequence of obstruction events, including refusal to accept filings, contradictory directives, hostile rejection of document, and punitive measure involving armed removal from the court. These allegations state a plausible First Amendment access to court claim as already recognized by this court. So, excuse me, I'm not going through all this. You guys could go look at it. Complete foreclosure applies at time of obstruction, not retroactive. Even if the complete foreclosure standard applies, it does not, because this is a forward-looking claim. Defendant arguments fail because foreclosure is measured at the time of obstruction, not retroactive based on later events. A prisoner, we don't care. Okay, y'all can go look at this by yourselves. Defendant's exhibits do not refute access denied. Defendant rely on exhibit 1 through 5. Appellate documents to argue plaintiff had access to courts. This reliance is both procedurally improper and substantively self-defeating. The exhibits are procedurally improper at Rule 12.6. B6. Rule 12.6, B6 requires the court to accept the allegations in the complaint as true and draw all interference in plaintiff's favor. Courts may not consider evidence outside the pleading unless the motion is converted to one for summary judgment under Rule 56. Exhibit 1 through 5 are not incorporated by reference in the first amended verified complaint. There are external evidence submitted by defendant. Their consideration would require converting the motion to summary judgment, which would be incomplete here because no discovery has occurred. Facts and disputes. Defendants would lose immediately on summary judgment without development of developed record. The court should either exclude the exhibits and decide the motion based solely on the pleading, or deny the motion because consideration of external evidence is premature. Get to the conclusion. All this stuff. All this is a response, child. The right was clearly established. The First Amendment right of access to court has been clearly established since Brown versus Smith. The fundamental constitutional right of access to the court requires meaningful access. Defendants argue that the Second Circuit distinction between forward-looking and backward-looking claims create ambiguity. This argument conflates two separate questions. Does the right exist? Yes, clearly established since Brown. What remedy is available? Debated in Second Circuit. Sousa noted that the viability of a backward-looking right of access claims is far from clear in the circuit. But Sousa did not hold that backward-looking claims are prohibited, only that the remedy structure is unsettled. Basically, he wants defendant's motion to dismiss to be denied, order defendant to file an answer to the first amended verified complaint within 14 days, permit discovery to proceed on all claims, and the alternative grant leave to amend if the court identifies any deficiencies, and grant such other relief as the court deems just and proper. Well, I would say that fourth one, the grant leave, it saved him. The courts may grant that. So let's get into it. Let me see. Did this fool? It's like, how, Sway? How? And usually they have the time up here. How did this fool foul on the same day? So defendants replied, the discussion. The proposed First Amendment verified complaint is the operative pleading. Defendants addressed their motion to the proposed First Amendment verified complaint because it is the operative pleading. Plaintiff arguments to the contrary are meritless. Plaintiff lodged the proposed First Amendment verified complaint as an attached to his objection to the report and recommendation regarding the original complaint. The court then screened this document, finding that plaintiff's first amended access to court claims against defendant survived the review. The court ordered that plaintiff amended complaint be accepted for filing as the operative pleading. Plaintiff is directed to file a copy of his proposed pleading as the amended complaint within 10 days of the date of this memorandum decision in order. Instead, plaintiff filed a different document, which he now claims is the operative pleading. As such, the document filed by plaintiff as the first amended verified complaint has not been screened and accepted by the court and constitutes a second amended complaint, which plaintiff must seek leave from the court to file. Accordingly, the proposed first amended verified complaint is the operative pleading. The screening order does not foreclose a finding that plaintiff failed to state a claim for relief pursuant to Rule 12(6)(b)(6). Despite plaintiff's assertion to the contrary, the screening order does not prevent plaintiff from seeking dismissal for failure to state a claim or the court from granting such an order. The screening order only considers whether the claims in the proposed First Amendment First Amended verified claim are frivolous as a matter of law, not whether it was subject to dismissal for failure to state a claim. In the Second Circuit, so long as the forma these Latin words is hard. Forma pauperis pauperis. Plaintiff raised a uh, plaintiff raised a cognizable. My bad. Cognizable. Where was I? Mm, Cognizable claim dismissal on the basis of factual deficiency, and the complaint must wait until the defendants attack the lack of such detail on a Rule 12(b)(6) motion. Nance versus Kelly, discussion screening pursuant to Section 1915D. See also Pillay versus INS, applying same rule under court's inherited authority. Accordingly, a motion to dismiss is an appropriate vehicle to challenge the sufficiency of the proposed First Amendment verified complaint. No matter how characterized, plaintiff's allegations are insufficient as a matter of law to state First Amendment access to court claim for relief. To avoid dismissal under the standard applicable to backward-looking access to court claims, plaintiff attempts to characterize his claim as a forward-looking claim of systemic denial of access. Regardless, plaintiff cannot sufficiently allege a violation of his First Amendment right because he was not denied access to the court. I believe so because he was inside the court. He had to get thrown out the court. He had to have access to the court to be thrown out the court. In Christopher versus Harbury, the Supreme Court recognized that First Amendment access to the court claims falls into two categories: forward-looking claims that challenge a systemic barrier to access, and backward-looking claims that challenges barriers in a particular case. Forward-looking claims challenges barriers like filing fees or lack of access to legal resources for prisoners. So, forward-looking claims challenges barriers like filing fees or lack of access to legal resources. Backwards looking claims challenges barriers are injuries that causes the loss or inadequate settlement of a, I want to say meticulous, but meritorious case, the loss of an opportunity to sue, or the loss of an opportunity to seek some particular order of release. Relief. Internal citation omit. In either type of case, the named plaintiff must identify a non-frivolous, arguable underlying claim. These cases, loss of an opportunity to sue or the loss of an opportunity to seek some particular order of relief. So is he's asserting a backwards looking claim? These cases do not look forward to a class of future litigations, but backwards to a time when specific litigation ended poorly or could not be commenced or could have produced a remedy subsequently unobtainable. Here, plaintiff is clearly bringing a backwards looking claim. He does not challenge a systemic barrier like a filing fee that is applicable to other potential litigants and foreclosed litigation altogether. Rather, he is alleging that in his particular case, defendants have erected barriers specific to him to prevent him from filing certain documents. As a backwards looking claim, this fails because plaintiffs admit in the proposed filing, admitted in the proposed first amended verified complaint that he was able to proceed with litigation in June 2025. Give me one second. I'm back. As such, his access was not completely foreclosed. Further, there is no legal authority for plaintiff's assertion that foreclosure is measured at the time of obstruction. And the law of the Second Circuit is it's clear that complete foreclosure is required. Even if plaintiff allegations are construed as a forward-looking claim, he is still not sufficiently alleged that a systematic official action frustrated him in pursuing his litigation. The systemic action must also be such that it affects a class of litigants. Here, while plaintiff alleged systematic obstruction from January through March 2025, involving 4 defendants acting in concert in his response, the proposed First amended verified complaint does not contain factual allegations to allow for a interference of systemic action. The only action complained of concern plaintiff, but the only actions complained of concern plaintiff, and there is nothing in the proposed First Amended verified complaint to suggest that other litigants face similar situations. Even if plaintiff sufficiently alleged systemic official action, he still has not sufficiently alleged an injury because he has not described the underlying cause of action that has been frustrated by defendant's action. The underlying cause of action, whether anticipated or lost, is an element that must be described in the complaint just as much as allegation must describe the official acts frustrating the litigation. Excuse me. in the proposed First Amendment amended verified complaint and attached document plaintiff provided the following information about the underlying cause of action. The action of defendant blocked defendant from ever obtaining a hearing on the merits of his jurisdictional challenges. The underlying action possibly concerned John A. Porter III versus docket in June 2025. Plaintiff caused a notice of motion to transfer case to judge due to bias and procedural violation to be served on Ms. Hayes. Oh my bad. Those motions were later dismissed without prejudice for failure to timely serve. In January 2025, plaintiff attempted to submit an objection to the magistrate jurisdiction, asked about an order to show cause and reference a petition he filed in December 2024. This is also a reference in the transcript from that date to a custody case. In a support case, it is a family court matter. This is insufficient to identify the underlying cause of action or to determine how defendant's action prevented plaintiff from filing or pursuing litigation. In fact, plaintiff does not allege that defendant's action prevented him from pursuing his litigation or prejudiced him in any way. Plaintiff failed to sufficiently allege a First Amendment access of court claim because 1, he was not completely foreclosed from court. 2, no systemic action is alleged. 3, he has not identified the underlying action sufficiently. Okay, my bad. Giving directions. Um, Almost done with this one. Defendants are protected by judicial immunity. Judicial immunity may extend persons close associates with the judicial process, including court clerks, deputy clerks, law clerks, and judicial interns who perform tasks that are judicial in nature and an integral part of the judicial process. Court clerks are entitled to judicial immunity related to the filing of court documents and managing a court calendar. Um, Here, plaintiff argues first the judicial cannot apply because the acts complained of were ministerial. His reliance on NYCPLR section 2102C is misplaced. Surrounding and other statutes makes clear that a clerk is responsible for making sure a filing complies with various rules before accepting a filing. Where a plaintiff claims that the defendants violated his rights by refusing to acknowledge his motion or to schedule his court proceedings, the defendants were assisting judge in performing essential judicial functions. As a result, the plaintiff's claims are barred by absolute immunity. Absolute immunity. Section second, plaintiff now claims the defendant's acted in retaliation or selectively enforce rules. However, plaintiff did not allege retaliation or selective enforcement in the proposed First Amended verified complaint. In any event, the law of the Second Circuit is clear that judicial immunity is not overcome by allegation of bad faith or malice. Finally, plaintiff claims that defendants were acting outside their jurisdiction because they were refusing to file documents which plaintiff believes is not part of defendant's job function. However, as noted in Marlis, judicial immunity even extends to a judge who intentionally orders others to bring a lawyer before him using excessive force. Because the acts of ordering a lawyer into court is a judicial function, even when performed in an allegedly unconstitutional manner, by extension, even if defendants erred in refusing to file documents, they still acted within the jurisdiction because they are empowered to file documents. Defendants are protected by immunity. As discussed above, absolute judicial immunity covers only certain functions performed by court clerks. For other ministerial, non judicial duties or purely administrative tasks, qualified good faith immunity attached. Public officials are entitled to qualified immunity on a Section 1983 claim unless they violated a federal statutory or constitutional right and the unlawfulness of their conduct was clearly established at the time. Internal quotation mark omitted. In determining whether a right is clearly established, court consider 1. Whether the rights was defined with reasonable specificity. Whether Supreme Court or Court of Appeal case law supported the existence of the right in question, and 3, whether under pre-existing law a reasonable defendant would have understood that his or her actions were unlawful. Here, qualified immunity applies because neither the Supreme Court nor the Second Circuit have held that errors in an underlying matter can violate a litigant's First Amendment right of access to the court. As discussed above, plaintiff's allegations are a backward-looking claim. The Second Circuit recognized forward-looking claims but has not recognized backward-looking claims. The viability of a backward-looking right of access claims is far from clear in this circuit. Therefore, qualified immunity protects defendant and requires dismissal with prejudice. With prejudice. Even if plaintiff alleged allegations are forward-looking claim, no reasonable defendant would understand that errors in filing could violate the First Amendment. As discussed above, the successful forward-looking claims challenge systemic barriers that apply to prevent a class of litigants from filing suit. In this case, plaintiff has not alleged a systematic barrier or a class of litigants affected by any barrier. All allegations in the proposed first amended verified complaint are personal and specific to plaintiff. Since plaintiff allegation falls outside of the usual pattern of forward-looking claims, defendant could not reasonably understand that their conduct was unlawful. Dismissal of the proposed First Amendment First Amendment verified complaint with prejudice is appropriate because amendment is futile. No amendment can change the fact that plaintiff cannot state a claim for relief. Similarly, no amendment can change the fact that defendants are entitled to judicial and or qualified immunity. Accordingly, dismissal with prejudice is appropriate. Dismiss that case. So he filed the same day. I'm telling you, I think he's copying and pasting. I think he's copying and pasting because ain't no way in hell. Like, how the hell you file the same day? How you know what they was gonna talk about? File the same day and type it up the same day and file it the same day. And it's 17 pages long. I'm not reading all this. The pleading issue does not warrant dismissal and is easily resolved. Defendant contends that plaintiff first amended verified complaint, no proposed, sir, filed is an unscreened second amended complaint requiring leave to file under Federal Rule Civil Procedure 15A2 because it differs from the proposed first amended verified complaint attached. This argument overstates a technical distinction and ignores both the text and structure of this court's October 16, 2025 memorandum decision and order. Why would they address it if it's improper? They addressed the proposed first amended verified complaint. That's what they did, and you complained about that. And so they told you why they wasn't addressing it. The courts already dismissed the county and directed a conforming filing. Oh my goodness, did he put the county back on there? Hold on a second, I gotta see. Did he put the county back on there? Hold on. Oh, that would be juicy if he did. They definitely gonna dismiss that crap. They definitely gonna dismiss that crap. Okay. No, he didn't put them on there. Okay. Directed a conforming filing. On October 16, 2025, the court conducted sua sponte screening of plaintiff's proposed amended pleading under Pillay versus INS. The court held that only the first amended access to court claims pursuant to 42 U.S.C. Section 1983 against defendant survived review. The court expressly dismissed plaintiff's Monell claim against Onondaga County Plaintiff's Manel claim against Onondaga County, however, failed to satisfy the same standard because Plaintiff Manel claim against Onondaga lacks a basis in law or fact. It is dismissed. Okay. Okay. Yeah, okay. Okay. He's basically copying and pasting what the judge ordered and basically the judge order and the dismissal of certain defendants. And I'm not about to read all that. The First Amendment claim is identical in both versions. No, they're not. Then you're lying under oath. Do you know that you can be held in contempt for lying? Because I just looked at it. Page 5 is not the same. The First Amendment access to court claim against defendant Primo. The only claims that survive screening is substantively identical uh, in docket 42-1. Substantively is not the same as identical. It means roughly. Defendant does not and cannot identify any allegations concerning to access to court claims that is absent. Their objection is purely formal and does not affect the substance of the rule 12.6 of 5 the 12b6 argument. Docket 44 is a conforming amendment, not a new pleading. It is. I just looked at it. It's completely different. Under Federal Rule Civil Procedure 15A, amendments to conform to the court rulings are routine and do not require leave when they simply implement a dismissal order. Amendment to conform to the court pretrial ruling are normally granted as a matter of course. Here, the court dismissed the county, pleading to remove the county. This is conforming, not amending. No, you like why is you? This is what I'm talking about. The manipulation here. The manipulation. Like I see it, you see it. You know what you did. You added some stuff that was not reviewed. Sure, you removed the defendants. Okay, you removed the defendants, but you also you also add some information that was not accepted, that was not reviewed. That's what defendants is saying. Defendant citation to Nance is an apposite. Defendant cited Nance versus Kelly for the proposition that screening only addresses frivolousness, not factual sufficiency, but Nance does not support dismissing a claim on the grounds that the wrong docket number is operable. Nance holds that defendants may still file Rule 12.6b motion after screening, which defendants did here. Plaintiff did not dispute that right. Plaintiff disputed only defendant's assertion that docket 44 is an unscreened pleading requiring leave to file. The court already screened the access to court claim. That claim is identical. There is nothing unscreened about docket 44. I want to see now. Now I want to see. But I feel like even if it wasn't, does it matter, Judge? Does it matter to you? Because I feel like it's going to matter. Okay, let's see. The venue, parties, factual information, procedure, pattern, cause of action. Let's see, cause of action. Yeah. All right, the cause of action. Yeah, the cause of action is not identical. Let me see. The proposed, okay. He dismissed them, so he had to remove that. Ugh. Okay. Yeah, but the prayer for relief section was changed substantively. Substantively. Let me see. Because I'm trying to see what else was changed. Uh, okay, so he had to remove that. Okay. Yeah, but still, even the relief is different. So I would be making a fuss about any and everything. Yeah. Okay, well, going back to that. What y'all think? Y'all think this shit gonna be granted? Gonna pass through? I don't think so. Uh, Plaintiffs adequately allege systematic obstruction. Defendants argue that plaintiff has not alleged systemic official action affecting a class of litigants and therefore cannot state a forward-looking claim. This argument misreads both Christopher and plaintiff's factual allegation. Systematic does not require multiple victims. Defendants confuse systematic pattern coordinated conduct with systemic affecting a class of litigants. Christopher does not require a plaintiff to identify other victims to establish systematic official obstruction. Systematic describes the nature of the conduct, not the number of people affected. Recognizing patterns where multiple defendants acting in concert interfere with plaintiff's right. Plaintiffs alleges coordinate multiple defendants obstruction, and he goes through it again. He goes through it again. The allegation demonstrates coordination, not coincidence. The amended complaint alleges Dixon after a private consultation with Primo reversed his initial acceptance. I wonder why, though. Plaintiff adequately identified the underlying cause of action. Defendants argue that plaintiff has not sufficiently alleged an injury because he has not described the underlying cause of action that has been frustrated by defendant's actions. Christopher requires only an arguable underlying claim. Christopher versus Harbury held that the underlying cause of action is an element that must be described in the complaint. But Christopher clarifies what this means. The complaint must describe the underlying arguable claim well enough to show that it is more than hope and to establish the remedy sought is not wholly conjectural. Plaintiff is not required to prove the underlying claim would succeed, only that it is arguable and non-frivolous. Plaintiff has adequately identified the underlying claim. Defendants themselves listed plaintiff's allegation. And they go through it again. The procedural entrapment demonstrates specific concrete harm. It's just a bunch of repeat. Defendants argument that plaintiff does not allege prejudice is incorrect. Defendants claim plaintiffs do not allege that defendant's action prevented him from pursuing his litigation or prejudiced him in any way. This is flatly contradicted by the amended complaint. License suspended, ongoing garnishment. I don't think that had anything to do with the motion, though. Plaintiff alleges retaliation in the complaint. Defendants claim plaintiff did not allege retaliation or selective enforcement in the proposed first amended verified complaint. This is demonstrably false. Retaliation is expressly alleged. The amended complaint alleges when plaintiff confronted O'Connor with proof, O'Connor summoned defendant Eckstein, who cleared the clerk area, summoned bailiff, and had plaintiff physically removed, an act of intimidation and retaliation. Judicial immunity does not apply to ministerial acts performed outside jurisdiction. Defendants argue that all challenged conduct is protected by judicial immunity because it relates to the filing of court documents. This argument fails both legally and factually. The acts alleged are ministerial, not discretionary. Judicial immunity extends only to discretionary acts of a judicial nature that are essential to the judicial process. Immunity does not extend to ministerial acts, retaliation conduct, acts outside judicial capacity, acts in clear absence of jurisdiction. The acts alleged here are ministerial and retaliatory. Defendants cite Argentinieri versus clerk of county for judge or clerk of court or no, I don't know. For judge Neotech, I don't know. In similar cases for the proposition that refusing to acknowledge motion or to reschedule court proceeding is protected. Argentiri involves a clerk properly enforcing filing rules. The plaintiff claims were dismissed because the clerk was assisting the judge in performing essential judicial functions by enforcing court rules. The case is different. Plaintiff does not allege defendants properly enforce filing rules. He alleged they accepted filing, then reversed. No, defendants are saying that whether they did it or not, they're still protected because they were assisting the courts, which hold the judges. Like, defendants misread in uniform rules. Yeah. Defendants claim that surrounding and other statutes make clear that a clerk is responsible for making sure a filing complies with various rules before accepting filing and cite NYCPLR 2101. This argument proves too much. Papers may be filed by delivery to the court, who shall note therefore the date of filing. Shall note is mandatory, not discretionary. Once a clerk accepts a filing and timestamps it, the clerk's ministerial duty is to dock it. The clerk has no discretion to make it disappear. Moreover, Dixon denial of receipt, O'Connor loss of timestamp filing, Eckstein's physical removal of plaintiff. These acts fall outside any discretionary filing management function. Acts in clear absence of jurisdiction are not protected. Even if someone's actions were arguably within plaintiff's general authority, immunity is lost when officials act in the clear absence of all jurisdiction. Here, defendant acted in clear absence of jurisdiction, denying receipt of mailing filing, losing timestamp filing, physical removal for asking questions, discriminatory access restriction. Well, sir, if you were causing a commotion, then they have every right to remove you from the court. Qualified immunity is premature and inapplicable. Defendants argue that qualified immunity applies because the law regarding backward-looking claims is far from clear in the Second Circuit. This argument fails for three independent reasons. Lord, it does not protect intentional violation, deliberate obstruction, retaliatory conduct. Qualified immunity requires fact-finding that cannot occur at the motion to dismiss stage unless the facts are undisputed. Here, the critical facts are disputed. State of mind, coordination, knowledge, pattern. These are factual questions that require discovery, deposition, documentary evidence, credibility determination. Court routinely deny qualified immunity at Rule 12b6 for the reason the right was clearly established. The First Amendment right of access to court has been clearly established since Bounds versus Smith. The Second Circuit has repeatedly recognized this right, including in Davis versus New York, which held that unreasonable, unjustifiable interference with court access can violate the Constitution, even when some fouling eventually occurs. Christopher versus Hembury reaffirms this right and clarified that official action frustrated is actionable. Souza versus Marquez applies Christopher in the Second Circuit. By 2025, no reasonable official could doubt that systematic obstruction of filing violates the First Amendment. The forward-backward distinction does not create ambiguity about the right. Defendants argue that Sousa's statement that the viability of a backward-looking right of access claim is far from clear in the circuit, creating ambiguity warranting qualified immunity. This argument conflates two separate reasons. Does the right exist? Yes. What remedy is available? Debate in Second Circuit. Moreover, Sosa itself recognized that the right exists. It merely notes uncertainty about whether backward-looking relief is available. This does not create qualified immunity for interference obstruction, but it does state that it wasn't established, like it wasn't recognizable. This argument fails for two reasons. First, plaintiff has alleged a systemic pattern of obstruction across multiple defendants and dates. Second, no reasonable official could believe that accepting filing and reversing after private consultation lawful, denying receipts of mailing documents lawful, losing timestamp, receipt filing lawful, physical removing a litigant from asking where his filings are lawful. I don't think it was just that. The conduct is not in a gray area requiring qualified immunity protection. It is plainly unconstitutional. For the foregoing reason, defendant's motion to dismiss should be denied in its entirety. Alternatively, if the court finds any deficiency in the pleading, plaintiff respectfully requests leave to amend pursuant to Federal Rule Civil P 15A. Shit, I had to do a whole goddamn application for leave. Well, look, I truly believe that if the judge does allow it through, he's just going to tell him, well, you need to refile. Like, okay, yeah, you can remove the defendants that were, the defendants that were dismissed, but there was other information on the amended complaint that was added. So you either want to file a second. I think that the judge most likely would allow the Mr. Porter to file a second amended complaint if he wants to add that information or ride with the one he has. But then again, like I said, I strongly believe that defendant's motion will be granted. So I'll be back with you guys to follow up on the status of that case. I'm gonna give it till next year before I check back in. I don't know if I'm gonna remember it though. How about I do this? I'm gonna screenshot it because, child, I don't be thinking about these people. All right, y'all have a good one. Please like, comment, and subscribe. And I'll get back to you. Have a good evening. Talk to you later. Bye.